name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, a series that I created in 2019, I'm going to be talking about eviction for failure to pay rent. So, failure to pay rent falls under Statute 83.56 sub 3. Once the rent is late and the default continues for at least 3 days, excluding Saturday, Sunday, and legal holidays, and after delivery of a written demand by the landlord for payment of the rent or possession of the premises, the landlord may terminate the rental agreement. This is often called the 3-day notice. Within the notice, the landlord notifies the tenant of the amount due, that the landlord demands payment of the rent or possession of the premises within 3 days. Again, excluding Saturday, Sunday, and legal holidays. The 3-day notice shall be made by mailing or delivery of a true copy, or if the tenant is absent from the premises, by leaving a copy at the residence. If a tenant is going to defend against an action by the landlord for possession of the unit for noncompliance of the rental agreement, the tenant must comply with Statute 83.60 sub 2, which I'm going to explain in a moment. Now, the court actually may not even set mediation or trial unless the tenant complies with that statute. Instead, the court must enter a default judgment for removal of the tenant with a writ of possession to issue immediately if the tenant fails to comply with 83.602. So what is that statute? Well, when a landlord sues for possession of a dwelling unit, or what is commonly called an eviction, if the tenant is going to raise any defense other than payment, then the tenant is required to pay into the registry of the court all accrued rent as alleged in the complaint or as determined by the court, and the rent that also accrues during the pendency of the proceeding. So failure of the tenant to pay the rent into the registry or to file a motion to determine the amount of rent to be paid into the registry within 5 days, again excluding Saturday, Sunday, and holidays, after the date of service of process, it constitutes an absolute waiver of the tenant's defenses other than payment. And the landlord is entitled to an immediate default judgment for removal of the tenant with a writ of possession to issue without further notice or even having a hearing. Quite frankly, many eviction proceedings end right there, and it's a rather quick process. Now, keep in mind that the information I'm providing you is statutory information and is intended to give you an idea of what this type of proceeding is, what it involves, and where to look for more information. It is not intended to be a substitution for legal advice. I mentioned it last week, but it's worth mentioning again that the Florida Bar has great consumer pamphlets that talk all about the landlord-tenant relationship. They have forms for a lease, and they have all the eviction forms necessary, including for defaults. If you find this information useful or you know somebody that could benefit from it, please like and share, and follow the campaign's social media. Do you have a particular topic you'd like me to address? Well, send a message through the campaign's social media or website. I'd be happy to film a video on your topic. Just remember that I can't talk about facts of your case or specific cases in general, but I can speak in an educational manner. And if you ever miss an installment of Scales, please visit the website or social media to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.